I'd like to welcome everyone. I'm Leah Wing, and I'm the co-director of the National Center for Technology and Dispute Resolution. And welcome to the 23rd Annual Cyber Week. We have an exciting panel, and I'm going to just give an overview of the context in which this panel is taking place, and I'll turn it over to our distinguished panel. We are celebrating the launch of the second edition of Online Dispute Resolution Theory and Practice, a treatise on technology and dispute resolution. It's an incredible feat that the editors, Mohammed Abdel Wahab and Dan Rainey and Ethan Catch, who's the father of online dispute resolution and the director of the center, have put together as editors, and we are blessed today to have a powerful set of speakers. I'm looking forward to hearing. I'm going to put this information in the chat in case you're interested in ordering a copy for yourself or for your university library or your town library. And I just want to point out that this is part of a 7-part series with all the authors being invited and the editors to present. We have 2 more presentations that will take place regarding the book, about how ODR is being infused and engaged globally, and they take place over the next 2 days. You can also check back at the Cyber Week program in order to look at past videos. Thank you so much for being here, and I'll now turn it over to Paul.
And Paul is trying to find the unmute button. So welcome everybody. I don't like to waste time up front. Richard Susskind, Larry Bridge Smith, both well-known in the ODR community, and I would encourage you to look at some of their stuff that they've done. I know Richard is a prolific author, and I love his work, and so with that, we'll turn it over to Richard and take it away.
Well, thank you very much, Paul, and hello, everyone. It's great to see so many, well, not everyone. I can see quite a few names and some friendly, familiar faces. Great privilege to be speaking to you. I think the first thing I want to point to is over my shoulder, sitting on my desk. It's a remarkable achievement, and I just want to start by congratulating the editors and the authors for putting together what is just the definitive book, the definitive work on online dispute resolution. I've just found it enormously helpful in the various things I do in life in the area. I've been asked to speak about, actually to speak about what I want really, because what I chose to use as my title is ODR in and near the courts. And hopefully what I'm conveying there is a sense that ODR is something that can happen beyond the court system, but I have some thoughts about the ways in which it can be more deeply embedded within our courts, and in ways I'll suggest that it can be annexed to our courts as well. So I have 25 minutes to chat with you, and I thought I'd organize my thoughts in this way. I want to say just a little bit about the context of my own thinking. I'm seeing Ethan there, who is indeed the father of the field. Compared to Ethan, I'm a newcomer to the world of ODR, but I want to explain to you why I come from a particular direction in thinking about this field. Then I just explain to you how it is when I'm speaking to lawyers and judges generally and lay people about the problem we face in our court systems globally. Then suggest to you the mindset we should have in thinking about the future. Say a little bit about the impact of COVID-19 on our courts, and as a platform, I think, for using technology more extensively, a tiny little bit about technology, and then suggest to you the 5 features I anticipate in our court systems in the future, and ODR and this idea of whether or not the ODR is in or near the courts. So the context for me was that although I'd spoken and written a bit about the field, I hadn't really taken it that seriously until 2014 when I was invited by the Civil Justice Council in England and Wales to, well, basically the top senior civil judge said, we've been hearing a lot about online dispute resolution. Is this a technique we could use to try and divert low-value civil claims out of the court systems to have them resolved more proportionately? And we put together a team and I chaired the group that looked at this, and we reported in early 2015. And one of our fundamental arguments was this. We said, there are indeed some really interesting techniques emerging, broadly speaking, in the field of ODR. But we think to identify them as private sector, as it were, alternatives to the public court system is to miss a trick. In the 21st century, surely, if we can identify, and we're seeing useful techniques for the resolution of disputes, then we should be looking to embed at least some of these within our formal court system. And all of this is against the backdrop of a fear I've often had about ADR as well as ODR, that I worry if our courts become increasingly distant from everyday dispute resolution, if the first port of call when people have legal disputes is not the courts, if they're regarded as arcane and outmoded, if they're regarded as 19th century institutions, if they aren't a daily reminder, a daily affirmation of the binding force of the law, then this is implication for the rule of law and not just for how we resolve disputes. It's important that we have a functioning, relevant, I believe technologically sophisticated court system. And so this is what we recommended, that we could embed some of these techniques within our court system. And it came to pass, although I think it's probably exaggerating, it is coming to pass that this is part of the UK's judicial and policy, well, I suppose government policy on the issue of the future of dispute resolution. But let me take a step back and try and capture the problem as I do during this period of what problem we face. Because of COVID, there's two problems. Many hearing rooms around the world have closed, and in consequence, because of the lack of availability of court systems, large backlogs are building up in many jurisdictions. And many people want to say that the access to justice problem has just arisen over the last couple of years because of COVID. But of course, this is nonsensical, because the reality is, even in 2019, in our most so-called advanced legal systems, if you take civil disputes as one illustration, then by and large, for most people, the resolution of these disputes costs too much, takes too long, the process is excessively combative, it's unintelligible unless you're a lawyer, and increasingly feels, I think certainly to everyone listening in, I suspect, as out of step in a digital society. And so we have this combination of three factors: the fact that hearing rooms have closed, the fact that backlogs have built up, and the enduring long-standing problem of access to justice. And just to put a little more substance to this, that some of the backlogs pre-COVID were stunning. A backlog of 80 million cases in the court system of Brazil, 30 million in the court system of India. And a statistic I like to quote, but depresses me every time. According to the OECD, only 46% of human beings live under the protection of the law. This effectively means that less than half the people in our world have realistic access to lawyers and courts. Less than half the people can find out what their legal entitlements are and enforce them. And I say this is to the collective shame of the entire legal and judicial professions. We must be able to do better. But to do better, we need a new mindset. And the question I ask, that I've been asking since the 90s, is this: is court a service or a place? Do we really need physically to congregate together? Or might there be other quicker, cheaper, better, less forbidding ways, more proportionate ways of resolving disputes? And I suspect, again, everyone listening in shares this view that to look at a court as simply a place is too narrow. We can all conceive of ways that we might effectively resolve disputes, but adopting more of a service orientation. And it's reminiscent of, I suppose, a story I tell every time when I speak. I'm sorry to those who've heard it before, but it's the old story of Black & Decker, who, when they train their new executives, say, we don't sell power drills, we sell holes in the wall, because that's what our customers actually want. And I say we need that kind of thinking when we're thinking of dispute resolution, because most lawyers and judges are of power drill mentality. They think, how can we make our service a bit quicker, cheaper, lighter? They don't think often enough, what's the hole in the wall? What's the fundamental value we bring to those that we serve within the justice system? Another distinction by way of mindset I often draw has been automation and innovation. The first 60 years of court technology has overwhelmingly been devoted to automation, by which I mean grafting technology onto our old ways of working, using technology to systemize, streamline, optimize our traditional court systems. And so many conferences and case administration systems, case management systems, information retrieval systems, and all the rest of it over the decades, these have largely been devoted to ways in which technology can be grafted on, as I say, to our traditional ways of working. What excites me more in technology is innovation, and this is my own definition, is the use of technology to allow you to do things that previously weren't possible. So that's the big challenge, I think, for the 20s, not to deliver mess for less, which is what we do by grafting technology onto our old ways of working, but to take a step back and ask again, using hole in the wall thinking, how can we use technology to allow us to resolve disputes in ways that weren't possible in the past? And then came COVID. I've been involved in a project, which some of you may be aware of, called Remote Courts Worldwide, www.remotecourts.org, where we've been charting and gathering news of progress around the world in jurisdictions moves away from physical hearings to remote hearings. And we've now, I think, 168 countries represented in that website. It just gives you a flavor of how many jurisdictions have actually snapped into action. And when we talk about remote hearings, we're talking about 3 different types of hearings. The audio hearing by telephone conference, the video hearing using much of the technology we're using today, and the paper hearing, which is not really a hearing at all, but that's when evidence and arguments are submitted to be considered by the judge on the papers alone. No oral evidence, no physical hearing. But I think it's clear now that the dominant mechanism during COVID period has been the video hearing, about which I want to make 5 observations. The first is that actually on many occasions, but absolutely not all, but on many occasions, video hearings have actually worked rather well. And I have to say, way better than almost anyone would have thought at the beginning of 2020. Let's be clear on that. There's lots of people rationalizing and saying, oh yes, I've always said video hearings is the way forward, but this is simply not true. The second observation, despite what I and others might have said in the past, is that when the platform is burning, it turns out that judges and lawyers can actually adapt very quickly. This has been noticeable, that particularly flexible and adaptable in moving from a very well-established, long-standing way of working to a very different way of working. And so we've seen that if the pressure is on, a genuine sense of urgency, we can as a profession respond. I think thirdly, many minds have been opened during this period to different ways of working, to recognizing that although, for example, in England, we haven't much changed the way we conduct court hearings since the 1870s, literally, people have recognized through the use of video hearings, oh, well, there might be some alternatives enabled by technology. And some minds have changed. I think more minds have been opened than have been fundamentally changed, but I think the mindset is different. But there is, I'm afraid, something that I refer to as a polarizing effect. I think we can divide the legal and judicial community into 2. Those who are saying extravagantly, we should never go back, we should use this technology on all occasions. And those on the other end of the spectrum, who I say are hunkering and hankering. They're hunkering down, waiting for the viral storm to pass, and they're hankering after the old ways. They just can't wait to get back into the courtroom. I find it rather unhelpful to conduct the debate as though it was a piece of litigation where there's 2 opposing views. Surely the future will be a blend of enabling technologies. And so to think that it's either we go back to the old ways or we take on board one technology that happens to have emerged over the last 18 months seems to me to be a rather limited view. Fifthly, I think it's often said that COVID-19 has accelerated technological change. And I think it's more nuanced than that, actually. I think in my terminology, it's accelerated automation, but decelerated innovation. That's to say what we've done is use the technology to help continue delivering the traditional service. How can we keep our court systems running? How can lawyers keep working through a variety of quite simple, straightforward technologies, in truth? But during this period, there's been far less conversation about fundamental disruption and transformation and revolution through AI and blockchain. It's not that these technologies have gone away, it's just that people have been trying to keep their heads above water. And so the short-term focus has been on using technology to automate and enable our ways of working when we can't physically congregate, putting on back burner the more advanced technologies. They will come back, but I think it's wrong to say in all respects that COVID-19 has accelerated our uptake of technology. And in truth also, the future hasn't arrived. I'm finding a lot of people are writing to me saying, well, Richard, your future's arrived. I think by implication, it's time for me to step aside and retire. I don't think the future has yet arrived. I don't believe home working is a full transformation of the judicial process. I don't think dropping hearings into Zoom is a shift in paradigm, as people want to say, because in truth, the people, the rules, the processes, and the problems remain much the same. So COVID-19, for me, is unfortunate, of course, but it's like a huge unscheduled pilot or experiment in the use of a fairly narrow set of technologies. It's regrettable, I have to say, in that context, that more data isn't being gathered about what works well and what doesn't work well. We desperately need to move away from policy making by anecdote, by judges and politicians. We need to move into the realms of having data which support the reactions, for example, of clients and court users to these technologies. So I have no doubt that there's much that's worked well in video hearing that we should preserve. And there's some occasions where we need to go back to the old physical hearing. But I want the decision on which way we go to be based on evidence rather than anecdote. And we suffer, I think, I speak only for England and Wales here, from people blogging and writing columns from their own, frankly, narrow and limited experience, where we should now have huge amounts of data, and we need to use that. So my view is that COVID, in short, should be regarded a little bit of a springboard for our community, for people who are concerned with online dispute resolution, because it has opened minds, and we should be thinking about different ways of resolving disputes against the backdrop of this horrendous access to justice problem that I've identified. So as some of you will know, I wrote a book in 2019, in November 2019, called Online Courts and the Future of Justice. Hardly anyone was interested in it at the time, but a few months later, along came COVID, and many people were more interested. In fact, they were wrong to be interested, because I wasn't really talking about video hearings in the book. Nonetheless, as an author, you don't turn down interest, so I didn't. But it did give me an opportunity in writing that book, essentially, to think through what some of the alternatives to traditional court service might be. And I've recently written an update, essentially in light of the COVID experience. And of course, my book was largely concerned with how technology would change dispute resolution. And it's worth just saying a couple of things about technology. We live in an era of what I call increasingly capable systems. Hardly a day passes where there's not some kind of news of a system application breakthrough technology. New systems often that are taking on tasks that hitherto we thought could only be taken on by human beings. And there's no finishing line. No one in Silicon Valley or China or South Korea is dusting their hands off and saying, job done, that's the end of technology. We are living at a time of more rapid technological progress than humanity's ever witnessed. It's happened on our watch, and the idea that somehow the court system and the legal world would be immune from these changes seems to me to be fanciful. And also, and this is a hard one to express, but I'm amongst friends, the reality is by 2030, our lives will have been changed by technologies that haven't yet been invented. I can't prove that, but anyone who's been looking at the trajectories of change over the last couple of decades will see this. I think it's likely that by 2030, our courts will have been transformed by technologies that haven't been invented. Again, I can't prove that. And whether or not it's 2035 or 2028 absolutely doesn't matter to me. What I'm concerned with is the overall direction. But in the end, the stats that seem to me to be hard to deny are these, that more people have access in our world to the internet, about 59% today, than access to justice, 46%. And that seems to me to be a remarkable indictment of the court system. So how can we use this platform, the internet, this remarkable enabling technology, to help improve access to justice? Well, I believe, and I can only just give a hint of the substance of each, but I believe the future of our court system lies in 5 different dimensions. I think we'll see the advent of what I call asynchronous online judging. We'll see, and I'll say a little bit about each. We'll see what I call extended court services, which takes us more clearly into the realm of ODR technologies. We'll also see the related phenomenon of what I call front ends, which is very much what I had in mind when I used the word near in the title of this talk. There'll be AI, which has been my lifelong interest. I wrote my doctorate in the 80s in Oxford in AI and law. My 5th decade I'm now in. And so clearly playing the long game here, but I think it will have come of age in the 20s. And another theme is dispute avoidance. So asynchronous hearings, that's the first phenomenon. Communications people will tell us communication is synchronous when the people communicating need to be available at the same time. A phone call, a meeting, a video call, you need to be available to do the communicating. In contrast, asynchronous communication is when you don't need to be around at the same time. A text message, a phone call, a traditional, not a phone call, a text letter, a text message, an email, a traditional letter where you write at your convenience and you pick up and respond at your convenience. Now, traditional court hearings have been synchronous. Everyone's have to assemble at the same time with all the cost, expense, confusion that causes. So one thought that I and others have had is the idea of the asynchronous hearing. And this is really, in some ways, judging on the papers alone. So the evidence and arguments are submitted by parties. There's some kind of online discussion and the judge delivers his or her determination. Similarly, at its crudest levels, a form of exchange of emails. Still human judges at this stage, but it's just a different way of conducting the process, probably more participative than the traditional adversarial proceeding. But we've seen examples of this, and I think it's working well. And I do think for low-value claims, and more importantly, for what I call the latent market, that's to say the countless occasions where people have justiciable claims but aren't able to pursue them, this makes sense as a cost-effective way of resolving disputes. The second recommendation I make in the book is more challenging in some ways, and I call this the extended court service. And I believe in the 21st century, our state should go beyond the provision of its primary function, which is the delivery of binding determinations backed by the coercive powers of the state. I think in a world where increasingly lawyers and court service is unaffordable, we need to plan as though the normal user is the self-represented litigant rather than the exception. We need to design systems not by lawyers for lawyers, but for non-lawyers to use. And therefore, is it beyond the bounds of our imagination in a technology-based society that our court service should also offer help to those non-specialist users, offer help to people trying to understand their rights and entitlements and obligations, offer help online so people understand the options available to them, tools to help them organize their evidence, tools to help them advance their arguments, tools that's going to the heart of traditional ODR to help people settle disputes amongst themselves without going before judges. Now, all of these options, I believe, and this is the idea of the extended court service, should not simply be or only be private sector services. I believe some of them should be baked into the court system. That would be a useful, affordable extension to our court services in the future. And I provide in my book a whole architecture for this. And I suppose the best example still that we've seen of this is the Civil Resolution Tribunal in British Columbia, where you see there's online judging of a sort, and you see the kind of tools and support that I mentioned. However, and thirdly, we have to recognize in light of COVID that because public sector budgets are being slashed, because there's a focus on catching up with the backlog, that going to governments and policymakers just now and saying you need to invest in a whole new layer of court service is unlikely to be a runner for the next few years. And that's why I did mention even in the early version of my book, but I think it's crystallized now, the idea of front ends, as we're now calling them in England and Wales. And this idea has been endorsed by Master Rolls, who's our leading civil judge. And the way he puts it is he'd like a kind of public-private relationship, partnership between ODR providers who are accredited by the state. It's not a service provided by the state, but it's a service that's accredited by the state. And it provides the kinds of tools I was mentioning, tools to help people understand their rights and duties, to guide them through the options available to them, to marshal their arguments, to organize their evidence, to provide early neutral evaluation, to provide online negotiation, and so forth. And the idea would be this is provided. It might be by independent businesses. It could be by charities or law schools or whoever, but they're accredited and linked to the court system in two ways. And the first way is that if the dispute is not resolved or dissolved through this front end, which it's the first port of call before you go into the court system, then there is an automatic transfer of all the case documentation into the court system. And we would argue there's a fast track for these cases too. Not everyone argues that. And secondly, and we're still working our way through this, that British Columbia have an answer here, we would want any determinations coming out of the front end to be enforceable as court orders. So there's an enforcement issue there too. And I think there's a lot more thinking to be done here, but I like this idea that an innovative entrepreneurial approach can be taken to the development of ODR services sitting beyond the court, but as satisfying various tests as yet unarticulated, would have a favorable relationship with the state. I'm conscious of time, but the fourth thing I wanted to say about the future is the coming of AI. There are, of course, two waves of AI. The one I was involved with, which essentially are rule-based expert systems, huge decision trees. And the second wave are machine learning systems based on huge amounts of data. And I think there's three main roles for AI in the future. The first two are for the extended court or for the front end. One is online legal guidance, the kind of tools and techniques you need to use to help people understand their entitlements and the options available to them, to draft documents and so forth. That's the diagnostic expert system. It hasn't died. It's still needed. It's at the heart of the Solutions Explorer in British Columbia, for example. A second kind of system, which is almost like a form of early neutral evaluation, are these systems that now predict the likely outcome of cases. And these, I think, should also be part of the front end or the extended court service. It is tremendously helpful for people, crudely speaking, to find out what the chances of them winning their case might be. That might be raw statistics on this kind of action, but now we're going far further in systems that, based on machine learning, can make fairly accurate predictions about court outcomes. The most radical development, which I talk about at length, I can only hint at today, is what I call predictions as determinations. And that's when, as these systems that predict the outcome of court decisions become more accurate, we can offer an alternative to court users and say, for example, in Brazil, your case will never be heard because the backlog's so large. Would you accept the prediction of a system? We developed a system that can make predictions based on our past court decisions and our past judicial work, that can make predictions very high degree of accuracy about the likely outcome in your case. Would you accept that as a binding determination of the court? You could say to the parties, if, say, the degree of certainty of the system is 95% or higher. Now, this is very challenging, and I'm not saying that this is better than human judges. I'm not saying it's a substitute for human judges, but it might be a way of settling disputes that otherwise wouldn't be settled in the court system. The final development I want to mention in conclusion is the whole idea of dispute avoidance, which I have for years called putting a fence at the top of the cliff rather than an ambulance at the bottom. I've never met a non-lawyer, and I use that term advisedly. I've never met a non-lawyer who would prefer a good big dispute well resolved by an expensive team of legal advisors and some clever judges to not having a dispute at all. That's not the way the non-legal mind works. Most people want to avoid pitfalls. They want that fence. And they also want what I call dispute containment, that if a dispute has arisen, then we can find ways of putting a lid on it and not escalating, as so often happens when lawyers and judges frankly become involved. And so historically, if I can put it this way, when people have been automating the court system, this has really been bringing the ambulance to the scene of the problem a bit quicker or equipping the ambulance a bit better. I think the next generation of systems and services we need to put in place, put that fence at the top of the cliff, both containing and avoiding disputes. That's a quick canter, Paul, through my thinking of the 5 characteristics of court systems during the 20s and an indication of how ODR will sit independently of that, will sit baked wholly within the court system. And also we're seeing the emergence of a hybrid approach as well. Thank you, everyone, for listening. Thank you.
Richard, as always, it's so great to hear your thoughts on this topic, and I can never get enough. So we are going to actually save questions for the end, but you can post them in the chat. So we certainly encourage you to use the chat for comments and questions. Larry, you're up, so please take it away.
You know, that is the most commonly referred phrase since COVID struck, is "you're on mute." So thank you for that. Sorry, all. It'd be very difficult, if not impossible, to argue the point with respect to what we've heard from Richard, because he's been with it so long, and so have others on this call. So the work that Ethan has done, Dan Rainey, Leah, Paul, the amount of thinking that has gone into our current state of ODR and its relationship to justice is just phenomenal. But that picture that was just painted is extraordinarily difficult to deliver. It hasn't been delivered over the 50 years of work that Richard and others of us have been trying to do. So there is this uneasy alliance, I think, that we're basically looking into a black hole without the certainty of what's on the other side. And forgive me, being an English major, an English literature fan, I'm reminded of the Great Expectations novel by Charles Dickens, one of the greatest of English novels, maybe the best, which begins with, "It was the best of times, it was the worst of times." And that story of Pip as he metamorphosizes from a urban pauper orphan, a suburban, a rural, and then moves into the world of gentility in London, was also written in an industrial age, the first, and in a post-pandemic age. Cholera had just ravaged London, and the story of Pip and his journey to maturity, I think, has some parallels for us, because there has been and will continue to be an impact. The most obvious, of course, of the pandemic has to do with public health and our own individual well-being. But virtually every sector has been impacted. And one of the most influential, I think, is that digital transformation, a phrase that has been used by business and technology for quite some time, has really energized both the business sector and the economic sectors of our society, as well as our social justice systems. But it has yet to disrupt or completely transpose the legal and the access to justice arena. So what has been the impact of the pandemic on justice? Well, we know about court-annexed mediation. We know about the great disintegration of the way in which access to courts has revolved. And just last month, a report was issued by the Social Market Foundation looking at law and making a pretty dire assessment of the impact of English common law institutions and their survival or survivability within the global economy. And although written from a business perspective, I think it's critical to note that a great deal of the deficiencies of our English common law, which virtually all of us on this call, whether we're in Canada, Australia, England, or the US, or any other common law country, we're all adapted to a system that has significant antiquity and value, but is losing ground with the global economy. We know about court backlogs and how justice has been impacted negatively. In Tennessee, a group including Steve Shields on this call, myself and others, were fortunate to be able to bring relatively quickly into the judicial system an alternative dispute resolution plan to address those backlogs related to COVID. And it takes that kind of effort on the part of collaborative teams to be able to address some of these big issues. It's clear that justice demands some basic components, including fairness with respect to both the process and the outcome. We expect impartiality as well as independence, and they are related but very different characteristics, all of which alludes to and then provides equal access to this system. Well, what do we have instead? Pre-pandemic, this is what is typical in most civil courts around the country of the US, long lines. Is it possible to literally move into that world which Richard just described of asynchronous justice, of the capacity to relate to our problems in an anticipatory way, using the technology of smartphones, AI? Of course it is. It's technically possible. And as Richard has said, we need to arrange our mindset to be able to achieve it. But we also know that the internet has its own black hole of challenges, including the security and the identity, the transparency. And as Richard indicated, if 59% of the population has access to the internet, even that suggests that the 40%, 46% of those who have access to justice, and the disparity there is even greater when you consider the 41% of the population which doesn't even have access to the internet, much less access to justice. And how do we help people acquire? These are the things that I think that we have concerns and need to address, and some have already begun to. Of course, in the United States, we've had the example, the pilot program that Utah had implemented, first in 2018, and even continues to be revised in the face of COVID. And the assessment that has been done of that online dispute resolution platform, even in its pilot and fundamentally beginning stages, clearly indicates that users are ready for online courts. When asked if they had the option, nearly every participant in a study said they would prefer to use a website over physically going to a courthouse to resolve a dispute. So this then leads to our understanding of what needs to be done differently. The report and its recommendations included a number of specific steps to be taken. When you consider them in their entirety, what they're talking about is the user experience and the user interface for justice. In other words, how does the technology get used, and how intuitive is it for those who are going to be relying upon it to either resolve anticipatory disputes or literally engage in those legal resolution procedures? There is a significant distance between anything that we're doing today in online dispute resolution and where these kinds of recommendations can be satisfied. And there are two concepts that I would like to focus on that I think that we in the ODR community need to pay specific attention to. And the first of which is interoperability. In other words, we can't wait for the perfect platform. In order to be of greater access and greater usefulness to both practitioners of dispute resolution and those that they serve, the technologies that we use will need to be more integrated with each other, so that, for example, a dispute resolution platform of whatever degree of robustness needs to be built with the capacity to integrate with meeting system platforms, document sharing platforms, communication tools. The intertwining of these immense numbers of application solutions is really going to be critical if we're going to go forward. And spending time, money, and professional resources in waiting for the perfect platform, to me, is a disservice to the community who needs it more effectively, more efficiently. We should be building our technology and dispute resolution to be integrated with the other tools and services provided by any number of technology applications. And the second critical component I think that has been missing in the whole process of designing ODR solutions is the process of human-centered design. When you look at the critique of the Utah system in all of its greatness and despite its innovative approach, it really is about the user that the changes and improvements need to be made. We don't need to come to our ODR solutions with a prescribed set of functions and features that are divorced from what the users need. We need to become more proficient in human-centered design, by which there's an enormous amount of research and study and practical advice and counsel about how better to build products, including technology products, from the perspective of the user, the client, the lawyer, the court administrative personnel. If we're not getting their input we're not building platforms or ODR solutions that will be of value to those who need to be used. And these are the characteristics of a good human-centered design process. And if you wish, and I'll share with you some resources at the end, there is a good bit of work done about the user experience, the user interface, the UX UI, in user-centered design. But the experience that I have been fortunate to have includes an event that our dear friend David Larson, who I know has been a part of others of these panels during the course of this Cyber Week, when in New York State, at the time, he and Vicki Rogers were working on the implementation of a court ODR system in the New York systems. And at the time, I was serving on the ABA Dispute Resolution Section Council and served as the liaison between the council and the section, who was in part funding this initiative, and David and Vicki. And over the course of that experience, which began somewhat haltingly, but ultimately was successful, as David's article points out, there were a lot of lessons learned. And had I not been a part of that, I would not have been able to appreciate the wisdom of David's counsel. So anyone who is engaging in an ODR implementation in a state court needs to read his piece. And it's an excellent introduction to how we implement ODR in state courts. For example, here in Tennessee, we were able to benefit from David's insights and experiences, and over a course of approximately 18 months, we were able to create an online dispute resolution system following David's great advice and ensuring that all stakeholders who would be impacted by a system were given the opportunity to provide input. So the notion that both interoperability and human-centered design thinking can be a part of a successful ODR implementation, I think we're fortunate to be able to say in Tennessee that we benefited from that approach, even though the time was not as fast as we would have liked, but the buy-in was so much greater. And as a result, I think that if we're going to proceed in this world, we need to take the advice and follow the examples of those who have been successful and are still working like all of us are in the trenches, trying to make ODR, especially in association with the court systems, more effective to truly deliver justice, both in terms of process and outcome, as well as in accessibility. And these are a few of those resources that I would recommend that you have at your disposal so that we can be a more effective group of practitioners in this arena based upon the experiences, the travails, and the difficulties that many of us have encountered over time. With that, Paul, I'm going to turn it back to you.
Great. Thank you, Larry. Great to hear your thoughts on that. And it's so fascinating to me how our presentations, Richard's, yours, and ours, blend together. So if the technology gods are favorable to me, I will share a screen here. I was telling Leah that I am a Mac user, and what's happened is I've been forced to use a PC, so I hope that this will work. Let's see. And there we go. So hopefully you are now seeing the screen. I'm not getting any, I got a thumbs up. Thank you. All right, so what we thought we would do is kind of look at some of the predictions and some of the thoughts that we had in our book, in our chapter, and talk a little bit about those. So once again, there we go. So mid-2020, we wrote that chapter, and we said, we quoted Chief Justice McCormick from Michigan. Coronavirus has done more for court technology, what more than 2 decades of concerted efforts could not. And so how did that play out? Well, great news is COVID forced courts to adopt remote proceedings and to relax the approaches. There was a significant reliance on technology. So most of us would say, wow, this is perfect, the perfect storm for ODR. Well, was that really the case? Well, actually what happened was that the adaptations, as Richard kind of pointed out, were urgent and reactive. They were not thoughtful. Court staff, what we find, were overwhelmed by technologies and by, because filings weren't happening, the increased caseloads were just overwhelming, the reduction of staff. And what ended up happening was this actually ended up kind of either delaying or precluding ODR. So many of the courts went to Zoom and said, wow, we've done enough, and we're in a happy place, and we're serving the public where they want to come to. So ODR, at least in many of the state courts here in the US, have effectively taken a pause. Another thought that we had was that courts would face budget cuts because of the economic impacts. Who could have predicted that the housing market would go crazy, with COVID? I thought people would hunker down, but no, the housing market went crazy, and all of a sudden there were, great pots of revenue coming in because of taxes. And what ended up happening was there were these COVID relief funds. Well, you're thinking, oh, wow, all this money is now coming into the courts. Here's another great opportunity for ODR. Some courts started to look at that. But what happened in many instances, not all, but in many instances, was that because they had huge pots of money, they started to take on the larger initiatives. ODR is relatively inexpensive to implement. And yet, you look at a case management system that they've had for 15 years, the courts are saying, wow, let's do case management. Well, what happens when you do large technology projects is you take all of your technical staff. And so you don't have people left over to do ODR and to do some of these other things. Reality is more funds are coming. So I'm helping out Nevada right now, and to look at the funds that they have and then the funds that are coming, some courts are even saying, our state can't spend the money that it's getting, and which is a great place to be in if you have the resources to implement ODR. Did you have any? You're good. Okay. So another thing that we said in mid-2020 was that the single most important factor to the success of court ODR is a strong, committed, tireless champion. And guess what? That is actually still the case. And what we have seen, unfortunately, is we have seen some of these champions who have left for other opportunities, and ODR implementations have fallen apart. I can give you 2 very real examples where states were making great progress on an ODR implementation, and those champions left, and they ended up, it ended up floundering and ultimately not coming to pass. So that is still a very, very key to a good ODR system.
Actually, that is one thing that I'd like to sort of point to, as Richard pointed to it. He's in his 5th decade. We're in our 4th and 5th decade. That there has to be a transition to a new and energetic younger generation to carry this vision forward. We're getting to the point where, you know, single efforts, single initiatives we point to over and over again, British Columbia, Utah, Michigan. I think they play a flagship and a really important role leading out, being these visionaries. But it's time we've got to have a new generation bring things forward.
Thank you. All right, another perspective. You know, whether or not a court makes ODR optional or mandatory is a significant policy choice. Well, that is still the case. And what's interesting is that in some case types, opt-in actually does work. So in traffic cases, opt-in, you get 70%, 70+% of the participants opting in. You know, there's lots of reasons why we can speculate and lots of reasons that are actually documented. But when you look at other case types like civil, the family and so forth, especially family, if you allow people to opt in, the numbers just lead to project abandonment. I'm not going to say failure because sometimes they do resurrect, as in the case of New York. So, but those projects do get abandoned if there's not a strong, significant force behind that. Okay, another perspective that I think we can all are very aware of, and that is that we have the civil upheaval tied to racial bias and to you know, the criminal justice in general. And what's interesting is that is still driving awareness. You know, I'm not going to say a lot on this because I think we all know that technology, you know, the study done by Orna and others about the effect, you know, of bias and, you know, does ODR eliminate that bias? And, you know, the numbers show that technology does help in eliminating a bias. And so the more we can do to leverage technology, the better. I know Richard talks a lot about AI, and, you know, AI is a great opportunity as long as we're not feeding it poor data. And, you know, that's the big concern I think that all of us have who have done any work in AI is just what is that data set that we're feeding it to learn. And you know, I can tell you that court data is really a bad starting point. You know, the interesting thing is that courts have gained technical expertise through the pandemic. You know, judges who said, I can never ever use technology are now, you know, pretty proficient at it. Excluding the cat lawyer. You know, I think we've all seen that one. So courts have gained technical expertise, but one of the interesting things is that, and Richard pointed this out, but you know, is this going to stay? We have a lot of judges who are saying they want to go back. And, you know, I used to think, well, you just want to go back because it's more convenient for you. You know, everybody comes to you, everybody matches up with your schedule. But I think in trying to think about this, that it's more nuanced than that. We know that, you know, we're all using Zoom. It's wonderful that we have people participating from Brazil and from, you know, all across the country and all across the world in these sessions. But I know that we also, you know, love to gather. We love to, you know, be able to be in the same room and exchange ideas and have those conversations that flow more naturally when you're in person than over a platform such as Zoom. And so I know that judges want to, you know, they're, for the most part, they are compassionate individuals who want to be able to, you know, kind of feel the aura of that person or whatever, and be able to you know, try to help that individual that they're about to you know, judge, that hey, I do care about you, I do care about your situation. So I think there's some nuance there, but the reality is that we do have a number of judges that want to come back. Do you have anything to say? Okay. So with that, I think that we're pretty good on time. So we have 15 minutes where we can entertain comments, questions, whatever people would like to do. So I'm going to stop sharing my screen if I can figure this out. Like I said, I am on a PC here, so that may or may not go well. So Leah, I'm going to moderate unless you want to, but is there anybody who would like to make a comment or has a question?
Stack up some questions.
Wow. Okay. We either overwhelmed everybody or we answered every single thing in the world.
I'll ask a question. There is so many threads that are exciting to build upon, but if I can go back to one of the parts of Lisa's comment and invite the panel to share a little bit more. I think one of the most important and exciting things that that the field has in front of it is the next generation. And so I wonder if you could speak to where you see the teaching and the training regarding ODR, not just the technical aspects, but also the large vision. One of the wonderful things about this panel is the fact that you're bringing such a broad vision, both about the past, but also about the future. And so how do we make that shift to having a new generation put their fingerprints on what ODR is going to be in the future?
Can I have a go at that?
Yes.
One of the things that's always disturbed me is changing a little bit just now, but in general, I don't think our law schools are taking the future seriously. When I find myself invited to speak to law students, they within 10 minutes, they've got a face, they've got faces on. No one ever told us that this is how it was going to unfold. We thought legal practice and court work was going to be much as it's been for the last 50 years or so. But once they get over that, and I make the point to them, I say it's given to very few generations of law graduates actually to be involved in changing the system. By and large, you've entered and participated in the system. And now there's the excitement of changing the system. I find that there's great enthusiasm, but we have to encourage our law schools at least to plant the thoughts that there are radically different ways of offering access to justice coming down the line, and that we need. I've been struck, and I've been interested in Ethan's view in this, that Ethan and I have been at this for ages. And I think I thought perhaps when I was working in this in the 80s and the 90s, well, soon there'll be some young people coming along and contributing massively. But actually, often the case that the best law graduates go into big law firms and disappear, or in England maybe go to the bar or continue in legal scholarship. I worry we're not attracting the sufficiently talented people to the broad field of legal technology, of which our discussion today is a part. So I think we need. I think the burden's on us to work harder on it, because if we're complacent, we're all destined to retire without having finished building the cathedral. I always said I hoped this court technology business wasn't a cathedral project, by which I mean with cathedrals, if you were there at the beginning, you were dead by the end. And if you were there at the end, you sure as anything weren't there at the beginning. And I said, surely surely modernizing our courts isn't a cathedral project, but as the years goes on, it's looking more and more like a cathedral project. But if we maybe accept that, let's make sure there are some people around at the end. So somehow I think we've got to stimulate interest in a new generation and encourage the most talented, frankly, who are in law school or who are doing this interdisciplinary study to think that this is a great career option to be involved with this. So the burden's on us.
Ethan?
If I may, as a professor as well, Ethan, I'm sorry, did you go ahead and jump in and respond?
No,
to
my perspective is slightly different from Richard's. I think I have been surprised at the amount of entrepreneurship in the legal tech arena. On the other hand, there hasn't been comparable entrepreneurship in the ODR arena. Of course, we could probably point to a variety of entrepreneurial efforts and ODR platforms, but I think in general, the activity in the legal tech arena has far outnumbered the entrepreneurship in the ODR community. So one can look at that and say, well, we're going to follow up on that. In the next few years, we're going to do comparable things. Or one could say there's some reason holding us back. I think my own view is of the legal tech activity, which there seems to be an enormous amount, follows on a decade or two of nothing happening. So is the glass half full, half empty? Thanks for calling on me, Richard, but I'm not sure what the answer is.
Can I come back and you think, I think you're absolutely right that we have seen, and there's a huge, literally thousands of young people involved with law tech startups. And I'm not criticizing or condemning the commercial motive. I was more thinking, are there people who are attracted to thinking deeply, the writing and the experimental and the more reflective and policy side? I think less so, and I can see why that might be. So I don't think we're in disagreement there, but you're probably right to be more optimistic that there are young people involved in the field, but wouldn't it be nice if there was a wave of articulate, well-researched, evidence-based advocates who are of a younger generation?
Yes.
Larry? To that, yeah, I was just going to add that there are so many dynamics at play in that question because technology tends to go to where the need is and the funds are available to meet it. And that means that if there's no demand, there's probably little opportunity. And that leads to the great work that is being done with organizations like LawTech UK or UK LawTech, the growth of technology from a government's perspective and its value with the governmental funding that can help create those solutions, I think is a part of the key. We don't have a lot of that in the US, and UK has demonstrated its willingness to go there. But to Richard's point, and I think it's absolutely accurate, my experience is that this new generation of people going to law schools where I teach and graduate business schools where I teach, they're very much focused on the digital transformation of both business and law. And are they academically prepared to become researchers? That's probably not the thing that they're most interested in, but they're clearly dedicating themselves to the opportunity to make a difference and innovate in the law, for which I'm very grateful.
So I love to tell a story about when I was invited to go to a law professor's class and talk about ODR. And I walked in and you know, everybody had a legal pad out and there was no technology. And I said, well, you know, why should I be talking about ODR when, you know, nobody here is using technology? And they all kind of looked sheepishly at the professor and said, she won't allow us to have technology. And so, you know, what are we communicating when we do things like that? I mean, I get it from the professor's standpoint. You know, she didn't want them doing Facebook and all of these other things. But on the other hand, you know, that's kind of the world that we live in, where kids think they can multitask and, you know, they're on their phone and, you know, all that. And so I think we owe it, you know, you know, at the beginning of their, you know, studies to actually be promoting, you know, that blend of the legal minds and, you know, understanding the law, but also understanding technology and you know, building the enthusiasm around that. Let's see. Somebody asked about the future. How do we overcome the algorithmic concerns if they are used in the legal system? So Richard, you have probably done the most thought work on that. So do you want to take a first pass?
Yes, thank you. And of course, the areas of greatest, I think, concern to the AI and ethics community and possibly are the issues of algorithmic bias and bias perhaps amongst the system developers, as well as the of the data. I think it's true to say and so far the problem of inexplainability. I think it's true to say early days, and you can have a purist or a pragmatic approach to this. There's a lot of very difficult issues yet to settle, and yes, there are, and we're seeing some interesting answers coming through. Pragmatists and me. Can people hear me, by the way, because it says my internet is unstable? Good. The pragmatism in me is my what I call the Voltaire riposte, the best. Often what we're talking about here is the provision of dispute resolution services where otherwise there would be none at all. And again, so it's, and I don't say this facetiously, it's the better than nothing test. That doesn't mean we should be in any sense complacent about these key AI design issues, but we shouldn't expect more from our systems than we get from our human beings. So in our human beings, we get bias amongst our judges and decision makers. In the data there is bias too. And in the question of opacity, I don't need to tell my US colleagues about the American legal realists who argued so very convincingly that the decisions judges give, their apparent reasons are actually ostensible rather than actual reasons, and they no more know the processes that led them to their decisions than we know the processes that lead some of these machine learning systems to their conclusions. And so I think these are important objections, the standard objections. But as I say, we should hold ourselves as human. B, recognize we're still at the foothills and improving, and C, recognize the game we're in here is not perfection but improvement, and offering access to justice under less than ideal circumstances, but better than nothing at all. And that better than nothing at all, I'm conscious some people might think sounds entirely complacent, but actually it's pragmatic. And I think finally I just want to say that while these are very important issues, there is the tendency, as with all early technologies, to fasten upon particular issues and regard them as knockdown objections. I don't believe they're knockdown objections. I believe there are obstacles we can negotiate.
If I can respond as well, I believe that we are all probably prone to the siloed effect of our areas of professional expertise and are not all that very comfortable with working across those disciplinary boundaries. And as a result, there's a great deal of work being done by a number of very responsible organizations, standard-setting organizations, governmental organizations, on how to develop and deploy ethical AI, for want of a better phrase. And for example, the IEEE, the International Engineers Association that creates standards for engineering, has an educational committee that's dedicated to ethics in education relative to AI. Those are just one of many, many organizations that any one of us could get involved with, and in doing so, learn how to talk across our disciplinary boundaries. I think our lack of multidisciplinary willingness is one of the greatest obstacles to creating the kinds of ethical applications, legally sustainable applications that I think we would all crave.
Great.
I would just
go ahead.
not sure whether I'm muted or not. I'll just add one or two things to what I said a little time ago. That is that there are two things that make me optimistic. One of them is not something to be optimistic about, but it's the increase in numbers of disputes. Technology, use of technology, the wider application of technology not only calls for new systems, but really requires us to recognize efforts to deal with the what Richard called the avoidance, or I would call the prevention of disputes. The other thing is that makes me somewhat optimistic is that over the last 2-3 years, ODR, I don't have to explain what ODR is anymore. I used to be routinely asked, the first question I was often asked was, what are you talking about? Where did I hear about ODR? At least the dispute resolution community, I never hear that question anymore. So yeah, a lot more can be done. A lot more should be done. But I think we're in a different state today than we were 2 years ago.
Well, I love the fact that the father of ODR got the last word in, so and it was optimistic. So with that, Leah, why don't I hand it back to you?
Thank you. I just wanted to take a moment to thank the panel. I think all of those who are listening can see the brilliance behind these chapters. And I particularly want to just say it's an honor to have people who've done so much work as leaders in the field prior to when it was even considered a field. If we think back about the work that's been done by all of our presenters, we're lucky that they took time out to share with us today. I encourage you to take a look at their chapters. Richard, we're honored that you wrote the foreword to the book. And so I just want to thank everyone for joining, and let's give a round of applause to our wonderful panel. We hope to see you all in future Cyber Week activities today, tomorrow, and Friday. And if the universe and human beings take good care of each other, then hopefully we can meet in Dublin in May in person for the next ODR forum. So take care, everyone.